Hey everyone, welcome to Wealth Redefined. I'm your host, Michael Reynolds, certified financial planner and owner of Elevation Financial. I'm on the web at elevationfinancial.com, as well as pretty much any social network you would be on. Estate planning, big fan of estate planning. Doing this a lot toward the end of the year. It's typically kind of an end of the year review task on my list and working with clients. And it's a big topic overall, but today I want to talk to you about choosing between a will and a trust and how to kind of navigate the two. And we'll see also shortly why it's not necessarily an either or choice as well. So we're going to talk about wills and trusts and how to give you the most peace of mind when you're deciding what to do. I'll preface this by saying, again, as everything on this show, this is not specific, advice. It's definitely not legal advice, not investment advice, not financial advice. This is educational. The only advice I give is directly with my clients that work with me one-on-one. So, all right. So when it comes to estate planning, ensuring your legacy, it's a process to ensure that your loved ones are taken care of. It's a kind of the cornerstone of that, to make sure that if you were to pass, if something happens to you, what happens? What decisions do you want to make in advance to assist and take care of those left behind? So some of the pieces of an estate plan include things like a will and or a trust, possibly both, which we'll talk about. So, both instruments have distinct advantages. They're tailored to different financial and familial situations, but they can often work together. Having one or both in place is part of establishing a basic set of estate documents that I think everyone should have. And that's, I've also had an episode on this show previous about estate documents everyone should have, and a will and a trust can be part of that. So you want to understand the nuances, the benefits of each one, and how they can make a significant difference in your estate distribution and your asset protection. So, whether you're younger, just starting out, whether you're, building wealth, whether you're close to retirement, the implications of these decisions are pretty important. So let's first briefly just talk about estate planning. Estate planning is the process of arranging for the management and the distribution of your assets after your death. So it involves making decisions about who will inherit your property, who will make financial and healthcare decisions on your behalf if you were to become incapacitated, how your assets will be managed and distributed. It can also encompass minimizing taxes and expenses associated with the transfer of assets and really ensuring that your wishes are carried out. So effective estate planning involves creating a comprehensive plan that addresses your specific needs and goals. It might involve the use of legal documents like wills and trusts, as well as strategies to maximize the value of your estate, minimizing conflicts among your beneficiaries, etc. So whether you have a modest estate or maybe more substantial assets, estate planning is really essential for providing financial security and that peace of mind for you and those loved ones potentially left behind. So let's talk about the importance of having a will or trust. A will and a trust are two of the most common tools used in estate planning. They both serve a similar purpose, but they do have some distinct differences in structure, function, and benefits. So a will is a legal document that outlines how you want your assets to be distributed after your death. It also allows you to name guardians for minor children and specify your funeral and burial wishes. A trust, on the other hand, it's a legal arrangement that allows a third party or a trustee to hold assets on behalf of beneficiaries. So having a will and or a trust in place is pretty important for ensuring that your wishes are carried out and that your assets are distributed according to your preferences. So without a valid will or a trust, your estate might be subject to intestacy laws, or you might be what's called pass away intestate, which, that dictates how your assets are distributed if there's no valid will. That means the state decides because you haven't decided in advance. So by creating a will or a trust, you can have control over the distribution of your assets and provide clear instructions for your loved ones. So a note here, a side note, there are many types of trusts, but today we're solely discussing a type of trust called a revocable living trust, which is the most common type of trust used in estate planning to complement a will. So we're just going to talk about that particular type. So what are the key differences between a will and a trust? So while both wills and trusts are important components of estate planning, they serve different purposes and offer distinct advantages. So you want to understand the key differences between the two, and that can help you determine which instrument aligns with your specific needs and goals. So the key differences between a will and a revocable living trust are centered around control, flexibility, privacy, and the legal process after death. So here's a breakdown of those differences. So first, let's talk about control and management during life. So a will becomes effective only after death. It does not provide a mechanism for managing assets during your lifetime. A revocable living trust, however, becomes effective as soon as it's created and it's funded. So you can manage the trust assets during your lifetime and make changes as needed. Next, let's talk about privacy. A will after death goes through probate, which is the public process, or I'm sorry, it is a public process. That means the contents of the will and the value of the estate become public record. However, a revocable living trust avoids probate, so the details of the trust and the distribution of assets will stay private. Next, flexibility and changes. So a will can be changed or revoked at any time during your lifetime as long as you're mentally competent. A trust can also be changed or revoked any time during your lifetime. Provides similar flexibility to a will. So they both can be changed at your discretion. Next, probate, which is the legal process after death. So a will goes through probate, which is the court supervised process of authenticating the will, paying debts, and distributing assets. This can sometimes be time consuming and expensive depending on what state you live in. Some states have easier probate processes that are less expensive. Some states have very lengthy and very expensive processes. In any case, there are typically fees involved and there's typically time involved. So those left behind kind of manage that process. A trust is designed to avoid probate. The assets in the trust can be distributed to beneficiaries without court supervision, often more quickly and with less expense. Next, protection against incapacity. So a will does not provide protection or mechanism for managing assets in the case of incapacity, where a revocable living trust does allow you to name a successor trustee who can manage trust assets if you become incapacitated. Types of assets covered. So a will covers all assets solely in your name at the time of death. A revocable living trust, however, only covers assets that have been transferred into the trust. So any assets not in the trust at the time of your death may still be subject to probate. So this is what's called funding the trust. You have to actually put assets in the trust for them to be subject to the terms of the trust. And then finally, cost and complexity. So a will is generally less expensive, is generally simpler to create. A revocable living trust is sometimes more complex to set up and might involve higher initial costs. All right, so what are the benefits and limitations of a will? So a will offers several benefits. It includes the ability to designate guardians for minor children, specify funeral and burial wishes, and distribute assets according to your preferences. It also provides clear legal document that outlines your intentions, potentially, reducing the likelihood of disputes among beneficiaries. However, there are some limitations to a will, such as its susceptibility to probate. That can lead to delays in asset distribution and expose the contents of the will to public scrutiny. So it's a public process. There are some limitations. It goes through probate, and all the limitations of probate and the features of probate kind of go with that. So a will might also not provide the same level of asset protection and privacy for that reason as a trust. So let's talk about benefits and limitations of trust. So a trust does offer some distinct advantages. It includes the ability to bypass the probate process, to maintain privacy, and provide ongoing management of assets for beneficiaries. So a trust can be especially beneficial for those with minor children. There's lots of reasons you might think about a trust, but one of the most common reasons I see is to set up a process for taking care of minor children under the age of 18. So a revocable living trust offers quite a few advantages for those with minor children, including one is management of assets. So a trust can provide really detailed instructions on how assets should be managed for the benefit of minor children. The trustee can manage the assets and use them for the children's education, for healthcare, for other expenses as stipulated in the trust. Also, it can provide continuous financial support. So a trust allows for a smooth transition of financial support to minor children without the delays of probate. So that can be really important for maintaining their standard of living after the passing of the parents. Also, there's control over distribution. So the parents can control when and how their children receive their inheritance. So for example, they can set up age-based milestones or specific conditions under which the children might receive assets. Also, it avoids probate. So a trust bypasses the probate process, which means the children can benefit from the trust assets without the costs and the delays that probate can involve. So again, it's an immediate transfer, which can be very beneficial to children. Also, privacy. Like we mentioned before, a trust does not go through probate, so the details of the assets and their distribution to the children don't become public record. So that can maintain family privacy and privacy specifically for your children. Also, you can do incapacity planning. So if the parents become incapacitated, the successor trustee can manage the assets in the trust for the children, which again ensure that their needs are met without court intervention. Also, there is special needs consideration. So if a child has special needs, a trust can be designed to provide for their care without disqualifying them from receiving government benefits. So a revocable living trust is a really powerful tool for parents, especially with minor children, to make sure that they're provided for in a way that reflects their wishes and that control they can have as well. So again, just a reminder that setting up and maintaining a trust might involve additional costs, and there are typically additional administrative responsibilities, especially when it comes to funding the trust. So, the assets have to be properly transferred into the trust to receive the benefits it offers. So that takes real close attention to detail. All right, let's talk about a thing called a pour over will. So I alluded to this at the beginning where it's usually not an either or situation. You're not picking between a trust and a will. You're deciding if you want to do a trust in addition to a will. So, after all this discussion, it might seem like a choice between the two, but typically it's not one or the other. So if you have a revocable living trust, it typically makes sense to also have a will in addition to this. And this is often called what's called a pour over will. A pour over will is an estate planning document used in conjunction with a revocable living trust, and it serves as a safety net for assets that have not been transferred into the trust. So here's how it works. So it complements the trust. The pour over will is designed to catch any assets that were not properly transferred into the revocable living trust during the person's lifetime. So it ensures those assets are distributed according to the terms of the trust. So it kind of catches anything that may have been left out of the trust and pours it, so to speak, into the trust. So the transfer of assets on death is handled by this complement or this combination. So upon the death of the individual, the pour over will stipulates that any assets outside the trust that are potentially subject to probate should pour over into the trust. And then the executor of the estate manages that transfer. So the assets passing through a pour over will still go through probate. But once the probate court has approved the transfer, the assets are then placed into the trust. So it also allows for a singular distribution plan because all the assets are eventually governed by the trust, even if they weren't initially placed in the trust. So it's kind of a safety net, kind of a catch-all, and it really simplifies your estate plan because it reduces the number of documents that dictate asset distribution upon death. Everything just basically kind of pours into the trust. It also names guardians for children. So the pour over will also names guardians for minor children. So that's a very important stipulation in the will. Now, keep in mind that the pour over will goes through probate. So anything not put in the trust will go through probate by way of the pour over will. So again, that part would be public record. So it's a really important component for those who have a revocable living trust because it ensures that everything outside the trust gets poured into the trust, and anything inadvertently left out still ends up there. So it's a way of, again, a safety net, kind of catching other assets, as well as things like naming guardians. So what are some factors to consider when you're choosing between a will and a trust? So there's several factors, and everything's a unique situation according to your specific needs. But, one is financial situation, family dynamics is a part of it, personal preferences. So if you have a relatively straightforward estate with, not a ton of assets, a few beneficiaries, a will might, suffice. A will might be fine to accomplish your goals. However, if you have, built more wealth, you have minor children, you've got a more complex family set of dynamics or specific wishes for asset management, specific control you want to put in place for distribution, a trust can offer that greater flexibility, as well as privacy. If you want to make sure that your legacy is private, if the transfer of assets remains private for those left behind in your passing, a trust is a big part of that. Trust can maintain that privacy. So what are some essential considerations when setting up a will? So make sure that your wishes are accurately reflected. Make sure you periodically review it. Make sure that if you have any changes in your circumstances, marriage, divorce, acquiring new assets, make sure you review your will. Make sure everything's updated. Also, remember, certain assets can be passed directly outside of the will through beneficiary designations, which is a good way to avoid probate without requiring a trust. Even houses can sometimes be assigned beneficiaries through a transfer and death deed, depending on your state. So, assets with beneficiaries assigned typically avoid probate and they're passed to heirs directly. So, that means in some cases, it's possible to get some of the benefits of a trust without actually creating one. So, in some cases, a will plus well planned beneficiary designations can be sufficient for many situations. So, keep that in mind. I'm not saying it's one or the other. Again, your specific situation is unique to you, but there are options. So, in some cases, let's say your children are, adults. All of your assets can have beneficiaries assigned. Maybe you also live in a state that has a transfer and death deed available for a home. Maybe you have, one child, no multiple beneficiaries to consider. You could, in theory, set up beneficiary designations for everything. Everything passes outside of probate, privately, outside the will, and the will just kind of covers a few basic things like, some family heirlooms or your burial wishes and things like that. So there's a lot of ways you can structure your estate planning with or without a will, and you've got options, and with or without a trust, I should say. So, what about setting up a trust? What are some considerations? So, establishing a trust involves appointing a trustee to oversee the trust administration. So, you're going to make sure that's someone you trust, no pun intended. The trust document should clearly outline the terms of the trust, including the beneficiaries, the distribution conditions, the trustee's powers and responsibilities, and especially properly funding the trust by transferring assets into its ownership or designating the trust as beneficiaries on assets that can do that. So this is where I would say, working with a professional really makes a lot of sense. So working with an estate attorney, a financial advisor like me, we often work in tandem. So working with a professional is super important when it comes to getting these documents in this estate plan right. So again, make sure you're looking for professional help if you have questions about this. And just kind of wrapping up, I want to always say that, estate planning is an act of love. It's a phrase I use a lot. And I love that phrase because a lot of us think, well, we're living in the here and now. We're focused on paying bills and making money and working and taking care of the kids. And it's always something, right? But these things we plan for the future, they don't often make it to our radar because they seem so far away, but things happen. Unfortunately, tragedy happens. People pass away. It unfortunately is a fact of life. And so being prepared for that occurrence and being ready for it, if it were to happen, is an act of love for those we leave behind, for our spouses and partners, our siblings, our friends, our children, those loved ones that are affected by our death will be very appreciative if we have set up our estate plan properly. And that eases the burden on those that are already suffering emotional distress from your passing. We want to make sure we make the administrative part of it as easy as possible. And that's a big part of estate planning, is making sure that you are properly establishing the structure and your wishes for those left behind to make it easier on them. So you want to take those proactive steps to plan for the future. It gives you peace of mind also, and honors those loved ones as well. So it's not just about creating wealth. Financial planning is a lot of things, but it's also about creating a lasting legacy and giving security to future generations as well. So as always, if you have any questions about this or anything else, I am happy to be available to chat. You can find me pretty easily on my website, which is elevationfinancial.com. You can reach out there. You can send me a note. You can book a complimentary money session to talk more about potentially working with me or just asking a few questions if you want. Or again, find me on social media as well. So with that, thanks for joining me today. Have a great day. We'll see you next time.